Lord's, reading of the Special Marriage Act, Section 21A must continue to apply to Hindu LGBTQ couples. That we are part of our societies and our communities. Our parents also long for our marriages just as those parents of opposite sex couples. They long to see that day, your lordships. So let us not assume, yes, there are cases, my lords, where a family may oppose a marriage. Those cases exist for opposite sex couples also. And how have your lordships and the union responded? Your lordships have responded by saying from a series of cases in Lata Singh's onwards that the state is enjoined to protect such couples. And the union has also risen to the occasion. The police protect such couples as today they protect us. When I'll come to my second point, which is on the evolution of the law of special marriage. Yes. Which commenced, my lord, in 1872. And prior to that, my lord, we would just shortly consider the Caste Disabilities Removal Act of 1850. So if my lord.
You know the questions that we have asking. You just formulate your points.
My lord.
Then what ideas you have,
my lord.
suggestion you have,
my lord.
You can just
my lord, I'm very
away. You will be able to easily appreciate that.
We wanted the other side to begin at 12.
Now
I think we can now start. If we can just formulate, we'll ask the others also to formulate 2 or 3 submissions and then read your.
I bow down, my lord. So if my lords will just briefly consider, then I'll come straight away to the second portion of my submission on 21A, which is the legislative history of the Act. And I'll quickly take your lordship through it. I won't trouble your lords with my note. In fact, the short point is this. In 1850, my lord, the British legislature introduces the Caste Disabilities Removal Act, which says that notwithstanding any loss of caste, excommunication, etc., the laws relating to property and other benefits which flow from customary law will continue to attract to a person. Thereafter, my lords, comes in 1872 the Special Marriage Act. As a result, my lord, as I understand it, of certain demands by Brahmo Samajis who said at that stage that they were not Hindus. And these were live questions, my lord, before the court as to who was included within a Hindu, within the understanding of the term Hindu, and who was not. And therefore, my lord, when the Act came in 1872, since a need was felt, as is felt today, that no community can be without a law of marriage, this statute required that a person give up their religion, surrender their religion, and therefore it's stated, I've set it out in the tables, that table A, my lord, at page 4, that marriage could be celebrated between persons neither of whom profess the Christian or the Jewish or the Hindu or the Mohammedan or the Parsi or the Buddhist religion, etc. So it required me to renounce my religion. Thereafter, my lord, in 1872, in 1923, comes Act 30 of 1923, which amended the provisions both as to who could marry under the Act, and secondly, my lord, as to the restrictions on personal law which applied. So, my lord, if my lords see, the first part was retained, that for certain communities, they still had to give up professing their religion. But now, the underlined portion, that marriages could be conducted between Hindus, the Buddhist, Sikh, Jaina, Hindu, so and so, or between persons, each of whom professes one or the other of the following religions. That is the Hindu, Buddhist, Sikh or Jain religion. And what we must understand, my lord, is at this time, until the coming into force of the Hindu Marriage Act 1955, this would have been the law for any intercaste marriage. Therefore, my lords, it followed, and I'm cognizant of the time, therefore it followed that, as I've set out in the second table, certain restrictions on the application of personal law were imposed, and at this point in time, it was the most onerous. If my lords will see table B, where I have given the provisions of Act 30 of 1923. Firstly, my lord, in 22, as now, it affects severance from the joint family. Secondly, my lord, the Caste Disabilities Removal Act, my lord. Thirdly, my lord, there were provisions that a man could adopt another son, my lord, in section 26. And my lords, under section 25, no person who adopted under this law would have the right of adoption, who married under this law would have the right of adoption. And under section 24, the Indian Succession Act would apply. Next, my lord, came the Special Marriage Act 1954. And this statute, my lord, is also in 54. We are in the middle of the debates about the Hindu Code Bill. And 1955, the Hindu Marriage Act follows. So now, for the first time, there is a unified civil law for the Hindus. There is a unified civil law of marriage for the first time. And under that law, intercaste marriage and intergotra marriage is now permissible. And therefore, the restrictions which are adopted in the application of personal law are modified to those under 19, 20, and 21, which we have today. In 1976 comes the final Marriage Laws Amendment Act, which brings in the provision of Section 21A, which now exempts those Hindu couples who marry under the statute from the provisions of 19 and 21. What, my lord, does this history tell us? As far as the application of personal law, since it fell from my lords, as far as the application of personal law is concerned, to a couple who marry, who may be LGBTQ, but who marry within their faith, those statutes which are contemplated as applying under Section 21A will continue to apply. That is my submission. Now, what will be the extent of the application? How will those statutes be read? These will be questions, my lord. Courts may hold, my lord, that we are excluded altogether, that there is no provision for the application. But how will those questions arise? In what circumstances? To which persons? Those are, my lords, questions which, as my lord Justice Bhat perhaps indicated, will arise on a factual basis with the passage of time in different circumstances. But my submission, my lord, would be this, that per se, in my lord's reading of the Special Marriage Act, Section 21A must continue to apply to Hindu LGBTQ couples. There can be no per se exclusion of Hindu couples who choose to remain within their faith for the matter of who they choose to partner with. In 50 years, I would submit, my lords, this section has not created any major difficulty with respect to its interpretation to opposite sex couples. And my next submission is this: my lords should not presume and pre-anticipate a difficulty which would arise for LGBTQ couples. On the one hand, the union submits that it would play same-sex marriage or LGBTQ marriage would play havoc with personal law. On the other hand, we tell your lordships that we are part of our societies and our communities. Our parents also long for our marriages just as those parents of opposite sex couples. They long to see that day, your lordships. So let us not assume, yes, there are cases, my lords, where a family may oppose a marriage. Those cases exist for opposite sex couples also. And how have your lordships and the union responded? Your lordships have responded by saying, from a series of cases in Lata Singh's onwards, that the state is enjoined to protect such couples. And the union has also risen to the occasion. The police protect such couples, as today they protect us when we approach the courts. And the state also responds by offering, for instance, under the Dr. Ambedkar scheme, under the Ministry of Social Justice and Empowerment, special schemes to promote intercaste marriage. So, my lord, it cannot be presumed, because today we are going through a process of social change, because today we are at the threshold. Neither this court nor I would humbly submit the state should presume that there is going to be a certain kind of outcome. They should see their people. It is not only a question of elites, my lord. We receive calls and we hear from young people across this country. From the inception of this case, my lord, I have received calls from people in Hisar, in Surat, in Chhattisgarh. When I asked, which district are you from? They said, which district? We are from Raipur, we are from Rajnandgaon, you name it. Let us not assume any more than we would assume at the outset of embracing any section of our society within the fold of law. Let us welcome them. Let the union welcome us and bless us as it would bless any other married couple, my lords. We seek those blessings. So, my lord, my last submission, therefore, is this, and now I promise I will wrap up, is that when it comes, therefore, after we marry, to the application of laws, the application of laws must be uniform for both same-sex and opposite-sex couples. On the one hand, my lord, there are general civil laws. For example, as fell from my lord the Chief Justice yesterday, of gratuity, pension, inheritance, succession, and so on. And my lords, those laws, the word spouse would be read in, the word husband or wife would be interpreted in a gender neutral fashion. And my lords, where a person would otherwise nominate their spouse of the opposite gender, today we would be nominated as spouses of the same gender. The other question, my lord, is the question of having children. Now, it fell from my lords, and very rightly, my learned friend, Mr. Vishwanathan, also said that today, perhaps not all couples wish to procreate. Not all couples who marry shall have children, and nor is having children a condition of any law. But my lord, as a couple, as a married couple, having a child is part of the human experience. And it may be something that some also long for. Today, marriage is a gateway for couples to have children as per the legal framework. So under, my lord, the JJ Act, the adoption regulations require that a couple have been married for a certain number of years, that there be a stable marital relationship and so on. This is, my lord, for a couple to adopt. Now, my lord, similarly, under the Surrogacy Act, only married couples may opt for surrogacy with some provisions. And the child who is born of surrogacy is protected under Section 8 in the same way as a child who is born of, let us call it, natural methods or a natural born child. Similarly, my lord, the adoption statutes say that at the moment of adoption, an adopted child, there will be a severance with the biological family, and the adopted child will have all rights and obligations as a biological child does. Now, what is the import of what I'm saying, my lords? There are already couples in this country who have children, LGBTQ couples, and those couples are also before your lordship. In the absence of the recognition of marriage of their parents, what the law does is it renders, just as it renders one partner of the relationship a stranger to the other, it also renders a child a stranger to its parent-in-law. That child has no relationship in law with one of its mothers who may love her equally as a mother in an opposite sex couple, who may do everything from morning to night as a mother does in an opposite sex relationship. But that child, my lord, without the protection of law, without the protection of adoption law, or the provisions of Section 8 of the Surrogacy Act, or similar provisions of the Assisted Reproductive Technologies Act, is rendered a stranger to its parents. That, your lordships have held on numerous occasions, is constitutionally untenable. A child cannot suffer because of the parents belonging to a protected class under Article 15. This is the sum and substance of my submissions, my lord. I'm grateful for a very patient hearing to this side. I'm obliged.